This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So a young lady was given a diagnosis by a doctor that she may be one of the contagious people in the current situation that I'm still not 100% sure whether I'm allowed to mention on YouTube. And she posted about it on Instagram in one of several posts. She says, "Sorry, I've been on a long break. I won't be back a while longer due to me now having the thing. I don't want the attention. It's just the truth. I am now in self-quarantine and I'm not allowed to leave my room or have an inhaler since they said, go home. Best of wishes. Love you guys." And then the police show up at her door and tell her to take down the post because she's inciting panic, using the same type of argument as you can't shout fire in a crowded theater. So the Wisconsin Institute for Law and Liberty sent a message to the sheriff explaining that this is more or less illegal and asking him to confirm in writing that the Cahoons, her name's Amy Cahoon, may freely exercise their First Amendment rights on social media, including by reposting the original posts that they were told to remove. And they asked the sheriff to issue a public written apology. They apparently did not get it because then they filed this lawsuit. Amy Cahoon or Amaya Cahoon, sorry if I've got your name wrong. I'm going to call you Amy because that's easier. Represented by her parents, and this is against the sheriff for Marquette County, Wisconsin, and Patrol Sergeant Klump of the sheriff's office. The First Amendment's protection of speech, especially online speech, is as vital as ever during the ongoing pandemic. The unprecedented stay-at-home orders throughout the nation have made social media one of the few outlets people have to communicate with friends and family. This case is about preserving the right to share our experiences with each other during this difficult time. A high school student who had a scare with the situation posted about her experience on Instagram, and a few days later, a deputy sheriff showed up to her home and demanded that she remove her post or be cited for disorderly conduct, arrested, and jailed. The offending post. By the way, who gets jailed for disorderly conduct while sheltering in place in home? That's not a thing. The offending post, a picture of the student while she was hospitalized, so not the picture we saw, but a different picture, while she was hospitalized for what doctors told her was likely the situation, with the caption, "I am still on breathing treatment, but have beaten the thing. Stay home and be safe. The sheriff's actions blatantly violated the First Amendment, and plaintiff is entitled to recognition of that fact." Amy Cahoon is a sophomore at Westfield Area High School in Wisconsin. Between March 7th and 15th, they went on a spring break trip to Disney World with their band class. While there, the county and country began shutting down due to the pandemic. Florida Governor Ron DeSantis declared a public health emergency March 9th. Let me just do a little bit of questioning about going to Universal and just Disney and all that during the pandemic, but okay. The parks closed on March 15th, and a public health emergency was declared in Wisconsin. Schools were closed March 18th, and she returned on March 15th earlier than planned due to the closures. 4 or 5 days after she returned, she began feeling ill. Her symptoms included a fever and dry cough, which are consistent with the situation. March 22nd, she began having difficulty breathing, so her mother took her to the emergency room at the hospital. The doctors evaluated her and concluded that her symptoms matched those of the situation, but they could not test her due to criteria at the time. They sent her home with an inhaler and instructions to strictly self-quarantine and to return if her condition deteriorated. They told her to quarantine for 14 days. The discharge order, a true and accurate copy is attached, diagnosed her with an acute upper respiratory infection unspecified. The doctors also gave the Cahoons a work release form specifying that the symptoms are consistent with the situation. Based on the information supplied by the doctors at the hospital, they believed that her symptoms were caused by the situation. After they left the hospital, they called their band teacher in charge of the spring break trip to notify about Amy's condition so that the school could warn other families and students on the trip that may have contracted the situation. Mrs. Cahoon was unable to reach the teacher, so she left a voicemail but never heard back. After she got home from the hospital, Amy posted a picture of herself. "Hey guys, sorry I'm on a long break. I won't be back for a while." This picture. Amy was self-quarantined until March 25th. Then her symptoms worsened and she was taken back to the hospital emergency room. She was redirected to a children's hospital who took her there via ambulance, and while in hospital, Mrs. Cahoon received a phone call from the principal at Westfield High School on an unrelated matter. Mrs. Cahoon told the principal about Amy's situation, including that she had left a voicemail for the band teacher, and once again suggested that the school may wish to notify other parents. The principal told Mrs. Cahoon that he would follow up with the band teacher, but the Cahoons never heard back. On March 25th, Amy posted a short update that she was in the ER and might need to stay. They do not have a screenshot of the post because it was deleted automatically after 24 hours. I guess she used an automatic deletion setting on that. Amy was finally tested in the evening of March 25th and received a negative test the following morning. She did not have the situation, but the doctors told the Cahoons that she still likely had it because she had missed the window for testing positive. In other words, it was too far after contraction in order to test positive. Consistent with what the doctors told the Cahoons, some health experts believed that nearly 1 in 3 patients who are infected nevertheless get a negative test result. They returned home from the hospital March 26th. At the time, she and her parents continued to believe and still believe that her symptoms were caused by the situation. After returning home, she posted again on Instagram, this time a picture of herself at the hospital with an oxygen mask on her face. The caption on the post read, "I am finally home after being hospitalized for a day and a half. I am still on breathing treatment, but have beaten the situation. Stay home and be safe." The Cahoons do not have a screenshot of this Instagram post because Amy deleted it in response to the threat of arrest as described below. During the evening of March 27th, Defendant Patrol Sergeant Cameron Klump from the Marquette County Sheriff's Office came to the Cahoons' home. Amy answered the door, and Sergeant Klump said he needed to speak with her father. After Mr. Cahoon came outside, Sergeant Klump explained that the school superintendent had complained to the sheriff about one of the Instagram posts. He showed her a copy of the Instagram post above, not this one, but the one with her in the hospital. Sergeant Klump stated that he had direct orders from the sheriff to demand that Amy delete the post, and if she did not, to cite her and her parents for disorderly conduct and start taking people to jail. Sergeant Klump's incident report confirms defendant's unlawful actions. Klump's report explains that Sheriff Conrath advised me he wished for me to respond to the resident and have the post removed from her social media. The report also states that Klump advised Richard Cahoon that if they were not willing to take the post down, there would be the possibility of a county ordinance disorderly conduct charge or for being arrested for disorderly conduct. Sergeant Klump states that Sheriff Conrath wanted the post removed because there were no confirmed cases in the county at that time. But neither Klump nor Conrath nor anyone from the school district had contacted Amy to discuss Amy's symptoms or learn what the doctors who treated Amy had told them, even though they had notified the principal and band teacher about the symptoms. Mr. Cahoon offered to show Sergeant Klump the documents they received from the doctors, but Sergeant Klump stated that he was not there to gather information, but to complete Sheriff Conrath's orders. Mr. Cahoon responded that Sheriff Conrath and Sergeant Klump had no right to demand that Amy remove her Instagram post, that he would refuse the order if it were his post, but that he would allow Amy to decide for herself. Mr. Cahoon then called Amy back outside, so that's her father. He told her that Sergeant Klump was going to ask her to remove one of her Instagram posts. Mr. Cahoon told Amy that she did not have to remove the post if she did not want to, but that it was up to her. Sergeant Klump then showed Amy the screenshot of her post and told her that if she did not remove it, he had orders from the sheriff to begin issuing citations for disorderly conduct and taking people to jail. Out of fear that Sergeant Clump would follow through on his threat to arrest and jail her and her parents, Amy agreed to delete the post. She showed Sergeant Clump her Instagram account on her phone as proof that she had removed it. Sergeant Clump then left the Cahoons' home. After Sergeant Clump left, out of an abundance of caution and fear, Amy also deleted her first Instagram post, but not until having saved a screenshot of it. Later that evening, the Cahoons discovered that earlier in the day, Westfield District Administrator Bob Miker had sent an update to families in the school district that included a statement about Amy's posts. Administrator Miker's update stated that it was brought to my attention that there has been a rumor floating out there that one of our students contracted the situation while on a band trip to Florida 2 weeks ago. Let me assure you there is no truth to this. This was a foolish means to get attention, and the source of the rumor has been addressed. This rumor had caught the attention of our public health department, and she was involved in putting a stop to this nonsense. So it's rumor and it's nonsense. Without investigation, without following up, without knowing anything more about it, it's automatically a rumor and nonsense. In times like this, the last thing we need out there is misinformation. I asked her to prepare a short statement for the purpose of this update, pasted it below. This statement does not name Amy or the Cahoons. Most of Amy's teachers and classmates would have been aware that it was about her, given that many of them saw her Instagram posts. The sheriff's threats to cite and arrest Amy for posting about her experience are especially troubling in the light of Miker's statements accusing Amy of not being truthful and engaging in foolish means to get attention. With the threats of law enforcement looming over her head, Amy felt unable to respond on social media to Miker's allegations, and she is now afraid of returning to school for fear of what her classmates and teachers will think of her. On April 3rd, undersigned counsel sent this letter explaining that the sheriff's and Clump's actions violated Amy's First Amendment rights and asking for them to acknowledge the violation and to provide written assurance that they will not violate Amy's First Amendment rights going forward. Between April 6th and 13th, counsel for sheriff and plaintiff exchanged emails. The sheriff declined to acknowledge the First Amendment violation or to provide any assurance that Amy and her parents will not be cited, arrested, or jailed for future similar speech about her experience with the situation. Instead, Sheriff Conrath stated that Amy's speech was not protected by the First Amendment, but was the equivalent of screaming fire in a crowded movie theater. And I thought we should maybe take that statement apart. Was her posting about her experience the equivalent of screaming fire in a crowded movie theater? You don't have to take my word for it. Let's look at the actual case. The case is Schenck v. United States, a 1919 United States Supreme Court case concerning the Espionage Act of 1917 during World War I. So keep in mind, we are during a time of war, and this is 1917, and it's involving the Espionage Act. Defendants who distributed flyers to draft-age men urging resistance to induction into in the draft to the war could be convicted of an attempt to obstruct the draft, a criminal offense. The First Amendment did not alter the well-established law in cases where the attempt was made through expressions that would be protected in other circumstances. In this opinion, Justice Holmes, said that expressions which in the circumstances were intended to result in a crime posed a clear and present danger of succeeding could be punished. The court continued to follow this reasoning to uphold a series of convictions arising out of prosecutions during wartime, but Holmes began to dissent in the case of Abrams v. United States, insisting that the court had departed from the standard he had crafted for them and had begun to allow punishment for ideas. But the court has set another line of precedents to govern those cases. So we're going to go over this case, and then we're going to go over one of the cases that limits the ruling in this case. So this is the case that said that you can't shout fire in a crowded theater falsely. One of the words that is often left out of Justice Holmes' opinion or statement is that he said you can't falsely shout fire in a crowded theater, as that creates a clear and present danger of people, inciting a panic, basically, or inciting a riot, which would be a crime. Schenck was the first in a line of Supreme Court cases defining the modern understanding of the First Amendment. Oliver Wendell Holmes Jr. wrote the often cited opinion because the events were not publicly known at the time. The United States' entry into the First World War had caused deep divisions in society, was vigorously opposed, especially by those on the radical sides, in this case the radical left, and by those who had ties to Germany. The Wilson administration launched a broad campaign of criminal enforcement that resulted in thousands of prosecutions. Many of these were for trivial acts of dissent. In the first case arising from this campaign, Balzer v. United States, the defendants had signed a petition criticizing the government's administration of the draft, threatening him with defeat at the polls. They were charged with obstructing the recruitment and enlistment service and convicted. When a majority of that court voted during their conference to affirm the conviction, Holmes quickly drafted and circulated a dissenting opinion. Real obstructions of the law, giving real aid and comfort to the enemy, I would have been glad to see punished. But I think that our intention to put out all our powers in aid of success in war should not hurry us into intolerance of opinions and speech that could not be imagined to do harm, although opposed to our own. So he was against convicting the people who had signed a petition. But the facts of the Schenck case were slightly different. Charles Schenck and Elizabeth Baer were members of the Socialist Party of Philadelphia, of which Schenck was general secretary of the party. The executive committee authorized printing and mailing more than 15,000 flyers to men slated for conscription. The flyers urged men not to submit to the draft, saying, "Do not submit to intimidation. Assert your rights. If you do not assert and support your rights, you are helping to deny or disparage rights, which it is the solemn duty of all citizens and residents of the United States to retain," and urged men not to comply with the draft on the grounds that military conscription constituted involuntary servitude prohibited by the 13th Amendment. After jury trials, they were convicted of violating the Espionage Act of 1917. Both defendants appealed to the United States Supreme Court, arguing that their conviction was contrary to the First Amendment. They relied heavily on the text of the First Amendment, which they said would have a chilling effect on the free discussion of the war effort. The court, in a unanimous opinion, this U.S. Supreme Court, held that the criminal conviction was constitutional. The opinion's most famous and most often quoted passage was this: "The most stringent protection of free speech would not protect a man falsely shouting fire in a theater and causing a panic. The question in every such case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree." Thus, the phrase "shouting fire in a crowded theater" has become a popular metaphor for dangers or limitations of free speech. But we have had limitations on this finding or this opinion, meaning that there's now additional restrictions on the restrictions, so additional freedoms for the freedom of speech and additional restrictions on government attempts to restrict the freedom of speech. Brandenburg v. Ohio was one of those, a landmark 1969 case interpreting the First Amendment. The court held that the government cannot punish inflammatory speech unless the speech is directed to inciting or producing imminent lawless action and is likely to incite or produce such an action. Specifically, the court struck down Ohio's criminal syndicalism statute because that statute broadly prohibited the mere advocacy of violence. In the process, other cases were specifically overruled, and doubt was cast on Schenck v. United States, on Abrams, Gitlow, and Dennis, which were three other cases that we did not go over. Real quick, Brandenburg was a leader of this organization in Ohio and contacted a reporter at a television station and invited them to cover a rally which would take place in Hamilton County in the summer of '64. Portions of the rally were filmed, showing several men in robes and hoods carrying firearms, burning a cross and making speeches. One of the speeches referred to the possibility of revengeance against these people. One of those speeches claimed that our president, Congress, Supreme Court continues to suppress the majority race, and announced plans for a march on Washington to take place on the 4th of July. Brandenburg was charged with advocating violence, but they're going to say that his statement in Revengeance was not a imminent threat, establishing a clear and present danger of lawlessness or inciting lawlessness or producing such an action. So if we go back then to whether or not stating that you have been diagnosed with a virus and that you have to quarantine at home, is that falsely shouting fire in a crowded theater such that it would create an imminent threat of violence or inciting people to lawlessness? No. No, it's not in any way. There is no interpretation of someone truthfully speaking about their experience with the current pandemic, how that would be a false incitation to violence or riot that would be creating a clear and present danger. No, I don't see any of those things being true. There's only a few pages left in this. Let's continue with their allegations and claims. The only thing Sheriff Conrath offered the Cahoons was a letter stating that his department's investigation is complete. This does not provide any assurance whatsoever that they will not be threatened again for future speech. Of course, the investigation into Amy's prior post is closed. Amy did exactly what defendants wanted in unlawfully demanding and then deleting her posts. They unlawfully demanded she deleted her posts. Given defendants' prior threats and their unwillingness to acknowledge their First Amendment violation, Amy reasonably fears that her social media is being monitored by the sheriff's office and that another deputy may show up at her door if she posts anything in the future about her experience or responds directly to Miker's accusations. Amy wishes to continue to post about her experience and her recovery and to address Miker's statements about her, but is afraid to do so. So she alleges a violation of the First and 14th Amendment. The way that works is the First Amendment applies to federal courts and federal governments. The 14th Amendment applies the First Amendment and the Bill of Rights to the rest of the state governments. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances. The First Amendment applies, and 42 U.S.C. 1983 allows people to redress any infringement of their rights by any state, etc., shall be liable for a deprivation of rights, privileges, or immunities secured by the Constitution. So that's the First and 14th Amendment under 42 U.S.C. 1983. And that's their only claim. So they're just claiming that the freedom of speech was violated. They want a declaration that the Instagram posts were protected speech, a declaration that the defendants may not cite them for disorderly conduct or arrest them for any of the above, an injunction preventing them from doing so in the future for nominal damages and for other relief as the court deems proper. What this usually means is you get some kind of damages for the violation of your free speech rights and your attorney's fees paid for. So that's a good lawsuit. That is a solid lawsuit that is pretty clearly unprotected infringement of the free speech right by the sheriff and the deputy and the sergeant or whatever his name is, Clump. That their behavior is not protected. I'd even go so far as to say that they don't have qualified immunity, because the law clearly establishes that this is not a Schenck or Brandenburg situation where something could be restricted. This is also not the Tinker situation where it is something that causes a substantial disruption at school. They're not even at school. She's quarantining. So, and it's definitely not misinformation either, as Miker had said. So at least under these facts, if the facts are different, the school district and the sheriff will get a chance to I'm sure dispute that. But I doubt the facts are different than what she said. It sounds very normal what she has said. She had symptoms consistent with the diagnosis, and so they told her to treat it as if she had the diagnosis. And so if someone told you to treat yourself as if you had the virus, then you would want to be able to tell people you had been in contact with, hey, you should get yourself checked too. How is that spreading misinformation? I don't think that it is at all. And it sounds like the sheriff and the sergeant and the school did absolutely no investigation whatsoever. But again, new facts could come to light. Let me know what you think in the comments below. So that is our show. Thank you for joining me. I'm Leonard French, your favorite copyright attorney. This is a community-supported legal education channel. Please consider supporting us by joining us on patreon.com/ljfrench or sponsors.com/law or Floatplane or YouTube memberships. The $50 plus supporters for the month of April get their names read out loud at the end of the videos. Thank you very much to Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. That's an awesome list. Thank you so much for your support. And thank you to the $5 plus supporters scrolling on the LED panel next to me and on the screen in front of me. Everyone goes in the description of the videos below. Always appreciate you. I'll see you in the videos that drop. Stay safe, stay healthy, wash your hands, social distance, and we'll get through this together. I'm Leonard French, your favorite copyright attorney. I'll see you in the next one. Love you all. Bye.